How long does patent protection last? If you're going to get a patent, you're probably interested in how long it may be good for. So in this video we're going to go over the different types of patents and how long they would each last for. Please keep in mind that over 50% of the retail money made today is made off products that are 2 years old or less, so while many inventors may focus upon whether their patent is going to be good 14 years or 17 years or 17 and 2 years from the day it is issued, they should be much more focused upon trying to make money during those first few years. Indeed, in my experience, inventors have about 5 golden years to make money off of an invention before something else better comes along, 5 years at the most. So rather than focusing on what's going to happen 14 or 15 or 16 or 18 years in the future, think about what you're going to do those first 5 years. Realize too that there are over 8 billion people in the world. A lot of them are smart, a lot of them don't like their day jobs, a lot of them would love to be inventors. So whatever you're thinking about, probably you're not the only one in the world who's thinking about it. So you really want to move forward with your idea, turn your idea hopefully into a patent application that'll issue as a patent. Hopefully it'll turn your idea into a prototype that's going to convince a buyer or an investor to invest in your project, and hopefully you'll succeed. So I have to begin this with the usual caveat that a patent application is not a guarantee you're going to get a patent. Now, I shouldn't have to do this, but you'd be amazed at how many people, especially first-time inventors, think that the patent application is the same thing as a patent. Well, it's not, and if it was this easy we wouldn't have patent applications, we just have patents. So you could just apply for a patent and it would automatically be granted. However, it's not that easy, and as an inventor you have to look at a number of factors that will determine whether or not you're going to not get a patent. So first of all, I made this graph sort of confusing, and I did it intentionally because you've got to look at all sorts of things. Did you do a prior art search to look at other patents that might be out there, or other items of prior art that might prevent you from getting a patent on your invention? Is there some hidden prior art that you couldn't find? Do you know your invention works, or are you sure it works? A number of inventors, they want to get things patented, but they don't know if their invention's going to work. So did you talk to an engineer or get some prototyping help? Did you even make a prototype to make sure your invention works before you try to patent it? Because frankly, even if you get a patent on something that doesn't work, no one's going to buy it. Did you budget enough time and money to see through this process? Are you sure you're really going to want to pay for patent prosecution 2 years down the road? When you get an initial rejection over some prior art, sometimes you pull a very difficult, or in some cases unreasonable examiner. USPTO examiners are a lot like regular people. There's some really hard-working ones that are easy to work with. There's some lazy ones. Sometimes you get an unreasonable one that just won't understand your invention, so you need to take this into account too when you're filing for patent protection. Last but not least, patent laws change all the time. You'll have new cases come down, new congressional acts, like we just had the Patent Reform Act a few years ago. Then you have court cases that tell everyone what the act really means. Now, most of these acts were drafted by lawyers, and lawyers aren't the clearest of writers sometimes, unfortunately. So sometimes you need a few court cases to let you know what a congressional act really means. So sometimes what is patentable today could be unpatentable tomorrow, and vice versa. For example, we had the Bilski case come down a few years ago that said that a number of business methods that used to be patentable suddenly are not patentable anymore. So again, just remember that just filing a patent application is not a guarantee you're going to get a patent. So assuming that you're fortunate enough to get a patent, let's talk about how long they're going to last. Well, the easiest is a design patent, because a design patent ends 14 years after the date of issue, and there are no renewal fees. So it's very simple. With the US design patent, you're protected for 14 years from the date your patent issues, and you don't need to renew it. You don't have to pay any maintenance fees. Basically, it's going to end 14 years after the issue date. A US utility patent is a bit more complicated. First of all, utility patents are normally good for 20 years from the filing date. Now, since from some of our